Thank you.
Item number 21, Mr. Kabir is appearing in this document.
Yes.
His album and it's still in the head.
Item number 20.
21.
21.
You appeared for the response number 2. I appear for the responding one.
On request of the learned counsel appearing on behalf of the petitioner,
No, respondent. For the respondent.
respondent. Respondent number 2.
I represent respondent number 1.
Please, before the next circuit, subject to its convenience.
Yes. Item number 27 and 29. Tomorrow I won't be available. We will take up today or otherwise next day.
Next circuit. 27 and 28.
29.
29. One minute. You are appearing in. Yes.
For the private respondent, some instance when it change beyond the private respondent, the item is 27. If it rejecting report, your option as the physically. So
I won't be available. I am leaving for
Next circuit. Next circuit on the request of the learned counsel appearing on behalf of the petitioner. Is the correction? কোথায় আছে copy? Where is the copy of the corrections? This was for correction.
Yes. This is for correction. The other side is mentioned.
Some mistakes are there.
I last one to the hour.
Without being translated has come with fingerprints.
Okay. One word missed out, that is without. In place of without, with being in. This instant regional this So this made which one?
No, this is 2, 3. And 2 and 3. Because we have to find whether the petitioners are a part of the union or not. And report has to be filed by the PBMC. No, I just
No, whether opposition and reply has been filed.
Not filed, my lord.
not that is a difficulty, not because they are saying that they are.
Will supply my letter. Never asked me. I would have
I have contacted the authorities. The only difficulty is we don't have the list of the members of the union because it is filed by the union.
What do you want now?
I want a list to be furnished so that we will verify the records whether they are entitled for the 130th or not.
I will give my letter, but now only my letter is fake. Or let it be in the next circuit because within a week I will supply. Similar or not?
This
Three, W 470,
three same.
four, yeah.
My lord, item of service is not affected, my lord. I seek a big time to serve the.
What is the matter about
I am seeking for caution of FIR.
FIR?
Yes.
FIR.
Hello.
Whether you have filed within time,
This is caution of FIR.
maybe. The revision
FIR was
must,
initiated
must be within time.
recently, my lord, within a month, I think. 31st of January, 2026.
Okay, you have. Affidavit of service we file on the adjourned date. Actually, say criminal revision must be admitted. Thereafter, question of service are not does not judge arise.
I can.
What is the procedure here followed by the judges?
Depends, my lords.
Because a criminal matter, there must be a some admission. There must be a section 5 application if deal. That must be admitted, and if arguable case is made out, then direction for service. Okay. Non-appears? Non-appears?
The text like that. I find this applicant
Who is the state?
Been instructed to appear, my lord, because I have been not got the copy, my lord. Let them, my senior counsel will give a copy to me, lord. That will be taken up day after tomorrow. I take instructions, I will make my submissions. Yes, ma'am.
How to have still the go down? Pass.
I don't know. Let me check, my lord, because I am. I will take instructions and make submission tomorrow.
They have license,
Yes, yes.
access or whatever, maybe they may cease and initiate proceeding. But if you seal the bar, is there any provision?
We have an excise regulation. We have an excise regulation in that.
But you have a license, you have a stock register, everything.
everything.
How you can see?
The provision
to
is
take
there,
instruction.
but that provision can be exercised by another authority under different provision of law, not by the SHO. SHO, what he is doing under section 34. Under section 34, he can't do these things.
He is the SHO.
SHO.
Who sees the property.
Yes.
No, no, such a. I am
How
appearing for
SHO can do
deputy
it?
commissioner.
Deputy commissioner did nothing. I have made it.
I
as
am
a
appearing for
party.
deputy commissioner.
SHO has done this thing.
See, inform other side state.
State, Sumit Karmakar is a
Give
big.
copy to him also.
Copy.
Yes.
Tomorrow.
Tomorrow. Today I will give you. Deputy commissioner and the other authority did nothing. I made them as a party only to show that if they have got anything to say with regard to the license.
This is totally within the domain of the excise department.
Excise department.
Even the police officer can search and seize
Can do it.
can do
Can
it,
do
but sealing is very difficult.
Excise commissioner is a.
Come tomorrow,
Yes, yes.
not to the.
हाँ देखो देखो बैठ जाए तो बैठ गया क्या?
Respondent, yes. What was the case?
This is that case, where my application, my student was not then found that as per section 159 subclause one.
Yes. Similar order has been passed by the
I have
coordinator.
taken instruction, Mala, they're saying that,
Instruction yesterday. Yes. What is the instruction?
they were under confusion that, he has got 4 plots of land under the same holdings. Even if we count that it is below 2 hectares. So that, the section is
Will not
applicable,
applicable.
no, it's not applicable in this present case. Because if we count the entire land also, it doesn't comes, more than 2
Below
hectares. It is below
200.
2 hectares.
So that they can be registered.
My lord, if my lord passes an order,
You are seeking similar order.
similar order is the page 31.
Similar facts.
Similar facts, my lord, yes.
Your movable property is number.
My lord,
What is the area of your,
total. My lord, not similar facts because the judgment which they have annexed, if my lord sees, it is, he has got the immovable properties in different locations. But
they have
here,
also different,
no, the same holding,
same holding,
same holding,
different plots.
different plots, yeah, different survey numbers upon on the same
Survey
holding.
number. So
If my lord sees, they have annexed
below
their
200 square,
2 hectares.
2 hectares, no, 2 hectares.
Page 18, my lord, they have annexed that record of rights. It's under same head, same holding, 1138. Holding number. All the 4 plots, all the 4 survey numbers is under the same holding. But in that case, my lord, it's says that it's of 3 different locations.
Your plot numbers is 441/1.
Yes.
441/2.
441 slash triple four.
Again 1.
Yes, 451 by 1. 4 survey
There
numbers.
are 4 plots.
4 plots under the same
And
heading.
total land is 1.9834 acres.
Below 20.
We intend to say the survey number
444 by 1.
by 1. Area is
Area is
7,160.
7160.
Square meter.
After dot, you cannot say 7,160. You have to say 7,160. Okay, tomorrow for orders. One another matter is also there, no? Similar matter.
One matter, my lord, that has already been posted to next circuit. ये किस में थी? No, that is of deemed permission.
That is different.
Deemed permission, sale permission.
I will take seat at 2 again. Yes,
Three to five.
Position 5.
My lord, I have five. On behalf of the administration, my lord, I have five.
Just inform the council for the requisition that the respondent, namely Jora, he has passed away. So his, our legal error has to be brought on the record so that this matter can be effectively adjudicated. Just inform to the other side.
Who expired?
Jora BB.
Respondent number?
It has got around 4, my lord. That is 4.
I'm sorry, I think I 26 or 125.
Taking extension of time to file my reply. On the last week only, they have given the effort to opposition and taking 10 days time to file the reply. They have given the effort of.
Extension to I think you are 7 of 126. Nobody is there. None appears on behalf of the. I think you are 13 of 126.
I have the petition. My senior appears for the respondent, my lord. There is a talk of settlement going between the
What
parties.
talk of compromise?
It is a case of easementary right.
So even my client has proposed that my client would be given some portion of her land. So that talk is going on. This may be placed in the next circuit. Possibly it is.
It is, when only 11. I think you are 15 of 2013, you are 14 of 20. 12 and 13. Not today. Non declares on the other parties, meaning ceremonies. In 14, you are 60 of 1986.
Appealing for the petitioner, this is an application under section 22. The counsel representing the opposite party has been served, but service particularly on the opposite party has not been effected. I'm seeking transfer of the matrimonial suit that was filed in the court of London additional district judge at Mayapur with the court of London family development.
It is submitted by the learned counsel appearing on the board. Take 15, CBS 44 of the.
Article 15 to 17 as per the petitioner, order has been complied. So all three matters can be discussed.
If 80, the 341 with 1990, number 2, 06 of
That was the petitioner in item number 80.
In
19,
For next circuit.
in 19,
This matter relates to my lord, pausing of the notification issued by the administrator with regard to imposing of some temporary war charges.
so you can.
There has been.
Is there any direction for filing opposition?
Their opposition they have filed. But your worship, Union of India is the relevant part. They have not filed any opposition. So far as I remember, Union of India has. not
Joint
filed
player of the
opposition.
learned counsel.
Problem.
I think 20, number 9, 1, 2 or
Subject,
something.
yeah, I'm appearing for official respondent, my lordship. I'm seeking some time to file the report, my lordship. Because
There is a transfer of Tahsildar, my lordship, so he is unable to trace out the document. We need some document to produce the same.
What is the matter?
It is regarding, my lordship, we received a complaint and we have taken a steps under section 161 of the regulation, of the local regulation. By stating
We
that,
are asking, setting aside is the impugned order dated 16th August 2023.
Order passed by this court in the same manner, order dated 11/12/2025 passed by this court.
11,
11/12/2025, which is part of the order statement. First,
that impugned order.
no, my lord. Order passed by this, my lord has also passed the complaint with that order. My lord may just once come to order.
Page number, which page number?
It's an order of this court, my lord, this proceeding. It's a repetitive order. Order sheet by the same.
Order.
Yes, ma'am.
Which order?
Order sheet 11/12/2025, my lord. Passed by coordinate page.
there is a direction to file report, my lordship, so I need some.
Which date you are saying? 11 December.
11th December 2025 order. Means.
Yes, field report.
My lordship, what happened, my lordship, some appeal was also filed. So the record was sent to the secretary revenue. So that's why we are unable to trace out the document with some 1 week time, my lordship, so that we can trace out the document and submit the report, my lordship, to comply the order.
Yes.
15, 16, 17, I was appearing for the contempt of blood. That is been compliant, so I brought your order.
I have already passed the order, dropped. Yes.
Obliged, my lord.
But this is that case, my lord, where that claiming for malicious prosecution. Again for the petition. No, as my lord has said,
You have to file the opposition.
no, I have filed. I have filed. My lord has asked us to. In order to that the case can be proceeded. My lord, I have perused the CD. The victim girl who used to be as an victim in this case, who has been raped and murdered, she was playing with
Otherwise, everyone can be implicated. Tomorrow, somebody will pick up you and behind the bar.
Nobody can have a right to take law in that. Everybody has.
Even a single minute is important for a life of a human being.
Right,
And it give a protections from the constitution.
right, like this.
This I am paying for next circuit.
Which one? 23. Okay, next circuit. Similar order, huh?
Waiting for exponent.
In this case, I'm playing for not for.
What is the matter about?
Will not take,
Opposition and reply filed.
Opposition filed.
Reply not filed.
also file, but meeting completed. Different.
What is the matter?
Whereas they have been awarded contract for construction of school.
Hmm.
Within 1 year, the school building, that Saja of the school building collapsed. And as such, some right for the court to,
Then, yeah.
action has been taken against him. Against that action, he has come before the court.
So what action you have taken?
They have blacklisted me.
Not like this, WLR, we have stated that he is, the WLR report.
Let him file the reply.
Reply has been filed, everything is
Reply is
complete.
Not filed. They have filed.
Reply has not been filed. This is regarding
2 and 3, I'm going
Is
to.
the demolition of, is the demolition of the was passed.
to demolish the illegal construction.
It's
It's not about illegal construction, it's about not sanctioned building. Relation to the sanction, may I say this, my lord? This writ has been taken out only because my lord, it's actually approved for the deputy commissioner. Despite pending of such appeal, my lord, the issue again and on. Again, we oppose the report protected our interest. Appeal is pending for the deputy commissioner, my lord.
What is the prayer here?
Prayer to request the order, my lord, on by the secretary municipal.
What was the order? What is the order?
Order seen at my lord,
page 36.
36. Before that, my lord, I filed my statutory appeal, my lord. It's appearing at page 34.
We have statutory appeal filed.
Yes, my lord, please kindly come to page 34, my lord, of the writ petition, my lord. Appeal is pending before the deputy commissioner. This is the appeal, my lord.
You have served the copy to the municipality.
Yes, my lord. It's appealing there, my lord. I even notice was put. Yes, appeal is pending for consideration before deputy. This writ can be disposed of, my lord, directing deputy commissioner to dispose of the appeal.
Yes.
But you are not
Right.
going party.
I just, but by admitting my writ petition, passed an order directing the authorities not to take any coercive steps since appeal has been.
But why you are?
Is there any interim order?
There, but subsequently couldn't able to extend that same, the same for the. Not followed up, my lord.
The court itself is not a party to this proceedings.
Who?
They are,
Municipality is the party.
We have passed,
So how you can demolish when there is a appeal?
we have passed the initial demolition order.
Eh.
The private respondent who is not a party to the proceeding, he filed oppose before this court by way of a writ petition.
Direction was given
Yes,
for
this court
implementation.
For, this court has said for giving opportunity of hearing for both the parties, and after hearing the parties, an order has been passed. So this is the second order.
it could have been filed an appeal against an order passed by the initial demolition, not a complaint order passed by the Honorable High Court.
No,
Yes,
but
yes, Your Lord.
what order has been passed in compliance to the
This order-
coordinate bench
That page
on
number-
36. That is subject matter of the appeal.
Yeah. But that
So that is the last order.
the direction.
That is the last order.
Yes, yes.
So that order
We
is
have to
challenged.
order an appeal before the demolition order, because the appeal lies against the demolition order.
That was not challenged. But ultimately, this is the final order.
This order cannot be challenged, but this is the speaking order passed in compliance with this direction passed with this order of the court. Lord, the appeal lies against an order of demolition before the first appellate authority. Not an order passed subsequent to that has been passed in compliance with the direction passed by this honorable court.
This court directed respondents to pass the.
That is not an order of demolition. That is an order of
This is an order, well, I
complaints.
complaint.
Complaints.
What I am praying, my lord, that this court be direct, becomes directed to dispose of the appeal, my lord. Speaking order.
But this is the subject matter of the appeal.
Yes, my lord.
So how?
Assume it, my lord, that speaking order goes in appeal. Then also the demolition order lies, my lord, it will stand the whole appeal.
You take action. Where is the problem? This order should be stayed.
Where the appeal has not been enclosed, what my
Yes.
elder brother is saying.
Where we come to page
34.
34 of the report.
Is the notice, is mere a notice.
No, it's a notice of
This is
appeal.
not an appeal.
It's a notice of appeal.
No, if a first appeal is there, number 28, against order dated 1/8/2024. And you have challenged another order.
There is another factor also here.
No, you have challenged the order dated 1/8/2024.
Yes, sir.
What is that order?
What's the order, my lord?
Where is that?
Next page, my lord.
35.
2024.
35.
Yes, my lord, page number 35. My lord, given this coordinate. This point, my lord, record.
Order, speaking order. Five is the speaking orders, my lord, see the first.
No. The appeal is filed against the order dated 1st August 2024.
It is a speaking order.
These orders, my lord, as I can put it, he has not enforced the demolition order. I will produce the original reports, my lord, with parents and fast necessary. Because there will be clearly.
Or proper and effective dis-
One and two. Lordship, I am for the petitioner. Very peculiar case, Your Lordship. When the petitioner was removed from the service, retrenched, he is a labor. So matter had been to the,
reply has been filed.
yes. Of course.
Copy served.
One and two, five.
No, reply.
One, both of them are filed.
Reply has not been filed. When filed
Your
here?
Lordship. I've always replied.
Yes, reply is filed. What was the order of the labor court?
Not labor court, Your Lordship. Conciliation.
Conciliation officer, the Labor Act.
Conciliation, then
Yes,
thereafter, that should be ref.
Why you are saying like this? Let me show the order. Kindly
So after, 20?
Seven.
Yes, 27.
This they have done before the conciliation.
Both the parties appeared to the
Yes.
consideration and decided to be
And
working
decided to
through.
engage the three workmen through outsourced manpower agency. The workmen agreed to this and hence the matter ends in settlement. Till today, they have not engaged. When they have assured that they will engage, why they have not engaged? Unnecessary reasons are there in the opposition.
Yes. Before conciliation officer, your employer has signed.
In the conciliation officer, that's been settled between the parties. Now the workman, who has to be, the employer has to be applied. That is the because they have.
Otherwise, it's punishment.
No, decided to engage the 3 workmen through outsource manpower agency.
Yes.
The workmen agreed to this and hence the matter and in settlement. So you have to engage them. Why you have not engaged?
Not engaged. I have given.
Have you seen page number 27? It is not disputed that they have not outsourced. They have admitted that they have been outsourced
Yes.
and engaged.
Outsourcing is tender and it is every year it has to be, but.
So once you are agreed before the conciliation officer, so you cannot deny it.
That's right, but.
Where is the provision? Please show.
Yes.
I think so, then a reference has to be done before the labor code.
Reference?
Yes.
Why?
Because
It's a punishment.
no,
No.
not the kind of
question.
as per the.
Reference only when there is no settlement.
Yes.
Not here.
But here-
is outsourcing, how they want to.
No,
implement.
Now it is settled and we agreed to engage them. You cannot deny it. Where is the provision? Please show. When you have engaged,
January 11. Initial engagement. Initial engagement.
My lord, the country comes to my opposition. I have elected.
and they worked 2011 to 2019 without any break,
Yes.
and November they have been disengaged. After this agreement, you have made a representation.
Yes, so many representatives. Number of representatives. Once they engage me, page number 28. Just to show for 6 months, thereafter completely stop. Then I started.
No, after settlement, they have been engaged.
Yes, once. Once for only 6 months.
So your cause of action, new cause of action arise.
Outsourcing, and that's where has to go on.
You cannot claim forever. You have admitted that outsource, I will engage.
Others are getting engaged, your lordship, just.
Your cause of action, your cause of action arose again.
How they have engaged other persons, even then, your lordship.
No. This settlement was made on 19th or 18th 11/2019.
Yes,
Thereafter, you have been engaged
for 6 months. Also.
6 months.
Yes, only for 6 months.
From when to when?
3rd January 2020 to 30th
3rd January to 3rd January to
30th June 2020.
30th.
June 2020.
So you again is this engagement,
Again,
disengagement.
again disengaged. I have submitted representation to the Labour Commissioner.
So again your fresh cause of action.
Let us take it in that way also. But I have submitted representation to the Labour Commissioner. Proceedings should be initiated. This representation is on this 25th August.
Yes, what is your view?
That is the first course of action.
So I have submitted representation.
Reconciliation, no, actually, reconciliation was done. Settlement was arrived, so there should be.
You consider their representation.
Yes, we have already submitted representation.
At least you send it to the conciliation.
Yes, let it be sent to the conciliation.
Where is that? Your representation?
Page number 29.
Page number 29. What is the date? 25th, no,
2020.
25th August?
Yes, it was, but it was received on 9th September 2020.
No, what is the date? Here,
25th August 2020.
August. A receipt of 9/9.
Yes.
This be considered and referred to the reconciliation.
Not that. On the basis of my representation, the matter has been referred to the competent authority. Page number 24. 30, I'm sorry.
After this.
After this. Kindly see.
The assistant labor commissioner.
24.
30.
Bro.
Page number 30.
What happened?
Nothing. Thereafter nothing.
Page number 40.
Yeah.
No result from conciliation officer.
This is. But the conciliation officer is not made as a party. But the labor commissioner has forwarded to the conciliation officer.
So he must decide.
Then he is not a party, if not is passing the direction.
Labor Commission is a party, that is sufficient.
No, how labor commissioner is relegated to the assistant labor commissioner? Page
Then
number
Labor
30.
Commission should decide it.
How should a labor commissioner
then
decide? This is the assistant.
Every
Sometimes
time, these
it is
poor
the
people,
answer.
these people, they are making the poor person
No, no,
suffer.
It is not a poor person. to
Of
suffer,
course.
Because they have.
Daily,
they have
he
good
wants,
document.
again, a
Which
repetition
they have
certified,
good document,
what
they are
case will be
enforcing.
transferred to the next
They
circuit?
not be
What does he want?
Now, what is the remedy regarding a non-compliance of any
Yes,
conciliation?
Section 18.
Hey, দাও তো বল,
Section 18.
industrial. বুঝলেন না, এখানে আমাদের আছে নি?
So your options book.
No, this is the fresh cause of action. Where is the provision if the conciliation officer do not act in accordance with law? The matter is pending before the conciliation officer.
But this is the second round of construction, which is they upload to the labor commissioner.
Yeah.
Forwarded to the assistant labor commissioner.
So what is the remedy?
No, now he has to issue notice to all the parties. He has to do reconciliation.
So what is the time frame for reconciliation?
As per the statute, if it is 45 days, if it is not done, they have to oppose before the labor court. I can produce that judgment, reason judgment, what Supreme Court has said. If it is been done within that 45 days.
45 days, if not done,
Not done,
then
they oppose before the labor court.
where is
So
that?
take it as a reference.
It is not mandatory.
Where is
They
that?
can. Just show it.
Where is that?
Not today, but I put it.
Tomorrow.
Yes.
Tomorrow at top court.
Even this honorable court can refer the matter
At
to the labor
the-
court. Not the judgment of the honorable court. It can be directly responded by this honorable court. or the labor court. Not required. That judgment, yes, that judgment that we pay. This honorable court only.
Okay, not today,
Directly
tomorrow.
to labor court, it has been transferred.
But before reference, we have to frame a question.
Yes, yes, your lordship.
So how this court can frame question?
No, certain matters are there where your lordship has referred the matter directly to the labor court. It has been done. I will place the judgment. This one.
So bring tomorrow
Okay, I will bring.
at top করে রাখো,
Yes.
top. 28, 27 already posted to the next sub. Yes,
No, I was a respondent, not. It's against the.
who is appearing for the petitioner?
Upon Kumar, sir.
What is the impugned order?
When it is in other development.
Demolition order.
Okay.
3rd October. Appellate authority order.
Yes, sir. Deputy Commissioner is passed.
So there is no second appeal. There is no second appeal.
Against the Deputy Commissioner order. The proceeding is going on before the Deputy Commissioner.
Where is the second appellate authority?
The status of the second appeal order, first appeal order, because they filed an appeal.
Now there I Arjun Swense first appellate authority is hereby uphold the order dated Swense.
That means
So,
they have to.
This is the first appellate authority
That has been, the demolition order passed by the municipal council
was affirmed.
Now, if they have agreed, they have to oppose the second appellate authority.
Where is
I
that?
don't know that they have not filed, sir. Because they said.
Where is the second appellate
They
authority?
have not gone second appellate authority. They said they have come to the court.
Where is that the second appellate authority? Here, tribunal. Tribunal.
On the complaint. In terms of the regulation, it was the honor of the.
Can you show me
Like bring the building bylaws, it is there. Building law.
second appeal?
Second appeal is like before the election.
So tomorrow,
Yes.
a non appears on behalf. If you can bring, I will send it to second appellate authority.
So they have to approach, they have not gone, my lord.
That's why I will dispose of.
And they have
If
to-
the provision is
and they-
clear, when they cannot drag this matter by filing a writ petition,
Yes, sir.
then there is an appropriate authority.
Right. Then happy, number 254.
In the next circuit, same time.
What is the matter?
Matter is by calculating the bidding capacity. of the
Okay,
tender-
Public Work Department.
Yes.
Okay, next circuit.
Wow, even 1,4%.
Friday is not possible.
I pay for this one.
What is the matter?
For that, the other day at airport authority, that's
Oh,
server number 6768.
now this can be disposed of. This is a public interest, large public interest is involved. Yes, madam, what is your instruction on this?
I'm opposing your lordship.
Because that plot number last occasion, so far I remember,
Yes,
his plot number is different. Barring that, you can proceed.
yes, I can.
That is
Yes.
fallen from my opinion. Where is the problem? None. Just you have to take instruction. If you do not have interest on another land, why you are involving in this matter? You concerned about your own. You have you have been recognition given of those land. That land is recorded in your name. I will stay them from them. Wednesday, tomorrow, not today. Take instruction. If they will not touch your land, where is the problem? Tomorrow you take instruction because last occasion so far as I remember, your land will not touch.
Hello, the proceeding is not maintainable under the law. I will place the law. It is not maintainable under the law.
No, why you are concerned about the other
No,
proceedings?
the proceeding is not maintainable under the law. So I will
In
place-
that proceeding, your land is involved.
Yes, my land is involved. When the proceeding is not maintainable in law, whether it can be done.
So show me tomorrow.
Yes.
They have their own regulation.
No, that regulation, in that regulation that it did not fulfill the criteria under the said regulation.
Okay, tomorrow I will.
The response.
Yes, where is the respondent? Respondent state
State.
or de facto complainant state. Where is the petitioner? Not today, choreographer. None appears on behalf of the petitioner. Not today. What is the matter? What is the matter? Yes.
Several pairs are there. Yeah, they yesterday my said they are one Supreme Court also because this message.
Oh. So again, they have created another cause of action and filed this.
This one.
Not maintainable, this petition. Okay, tomorrow.
Not in this, we are filing the opposition.
You have filed.
They are fine, they are giving the copy.
You give. You have already filed in. Reply has already been filed. Likho na 34. 34, huh? Again reply you upon reply. Opposition.
You have a response 2 and 5.
It's a affidavit in opposition. Filed on behalf of